Hi, my name is Adam Bolatin. I'm competitor number 26, and I am representing Nancy Claus. Minimum care. That's what this case comes down to. What the law defines as minimum care. Twitter does not define minimum care. Facebook does not define minimum care. Public opinion does not define the law. But in this case, the state allowed just that to happen. They allowed Facebook, Twitter, and public opinion to dictate how they proceeded. The state's decision to press charges on Nancy.
Does the statute mention anything about shelter?
No, Your Honor, it does not. Nancy provided heated food, heated water, and insulated dens.
Counsel, would you please refer to your client as Ms. Claus?
Yes, I will, Your Honor. Thank you for that. Miss Claus loves Shelties, and she's loved Shelties since she was a kid. Today, she still loves Shelties, whether she's raising them for other families or keeping them as pets.
Counselor, sorry to interrupt. Isn't it true that Ms. Claus took out one of her own pet dogs in a coat the same day that Shelby passed away due to these conditions?
Yes, Your Honor. It's true that Nancy had 2 Shelties that she kept as pets. She also bred and raised 46 other dogs that she was preparing to live lives, assisting with farmers with herding and working outside. And despite our own personal beliefs about breeding dogs, dog breeding is not a crime. The ABC, the American Breeders' Club, the club that sets the standards for dog breeding, not only certified Nancy, but they featured her in their Shelties in a Spotlight series just this past year.
That certification doesn't provide anything regarding standards for minimum care. Is that true?
No, it does not, Your Honor. But the fact that the club that sets the standards for dog breeding certified her and featured her in their Shelties in a Spotlight series shows that they were aware of Nancy Claus and shows that they were aware of how she was treating her dogs. Nancy isn't some type of ruthless profiteer either.
Wait, I'm sorry. Is there evidence that the woman who testified for the breeding club actually knew anything about the conditions that Mrs. Claus's animals were being kept in?
No, Your Honor, but I believe it's a reasonable inference. If the ABC, the club that sets the standards for dog breeding, certified Nancy, did a story about her, it's a reasonable inference that they would have known what she was doing. They would have asked her questions, and they would have seen the way that she was breeding and caring for her dogs. Nancy's not a ruthless profiteer. She's a woman who's just scraping by. A few years back, Nancy lost her husband, and for a while, she volunteered at the local library, reading stories to little kids. But after a while, she would lose this too. Nancy was alone, without any way of paying her bills, and that's when she turned to breeding her dogs. These dogs, they weren't her.
So isn't the inference then, the reasonable inference, that she was raising these dogs for profit, not for personal pets?
Absolutely, Your Honor.
And this was her exclusive source of income?
Yes, Your Honor. And because it was her exclusive source of income, it makes no sense that she would subject her only way of making money to harsh conditions. If these dogs passed away...
Well, harsh conditions. State's Exhibit 101 shows a thermometer that was taken, a temperature that was taken at the scene here where these dogs were outdoors, and it shows 5 degrees. Water freezes to solid ice in weather that is 27 degrees warmer than that. I mean, can any living thing survive these types of conditions?
Your Honor, the temperature of the thermometer only showed the temperature outside the dens. The only temperature that mattered in this case was the temperature inside the dens that were insulated with hay, the dens that had heated bowls of food and water. But Sergeant Stone never checked that temperature.
Would you agree that one dog suffered frostbite?
No, Your Honor.
No dog suffered frostbite. What about Cleo?
No, Your Honor. It's true that there's testimony in the record that Dr. Vogel examined Cleo.
Isn't that uncontradicted?
No, Your Honor, it is contradicted. There was the testimony of Dr. Vogel that she allegedly saw blue markings. However, as the record reflects, Dr. Vogel is inexperienced. She was pressured not to mess up. The fact that the state did not present any piece of evidence showing, documenting what Vogel saw that day, whether it was her necropsy report, reports of her examination, pictures of the dogs on February 5th, pictures of Cleo on February 5th. The fact that the state did not choose to show any of those pictures, Vogel's...
Is it your contention that Dr. Vogel is so inexperienced that she is unable to diagnose simple frostbite in a dog?
Your Honor, it's our contention that the state has not proved beyond a reasonable doubt that Cleo suffered from frostbite on January 5th. And that's because Vogel provided testimony that she saw alleged blue markings, that she saw alleged frostbite. But it was the state's job to present every piece of evidence showing pain, showing suffering.
Didn't you call an expert too, and we didn't hear from Dr. Gruff that there was no frostbite, correct?
Well, Dr. Gruff did not see and diagnose Cleo that day.
And didn't we also have evidence that the dog's temperature was woefully lower than normal, number one, and number two, that when the dog's temperature was taken, it had already been warmed in blankets and was in a warm car for 30 minutes?
Well, the dog's temperature, it's true that there's testimony in the record that Cleo's temperature was 2 degrees below normal. However, we don't know what Cleo's temperature usually is. It's possible that Cleo's temperature remains below normal. It was never presented in the record that Cleo was always at a certain temperature in line with a normal dog's temperature. The state has brought 3 charges against Nancy today.
The animal neglect statute mentions an exception for normal animal husbandry practices. How does that factor into this case? What should we think about that?
Well, Your Honor, taking in consideration the statute, it's true that animal neglect in the first degree does mention that nothing in this section should be taken to not allow normal husbandry practices. However, dogs do...
Is it normal husbandry to allow an animal to die?
No, Your Honor. It's never normal husbandry to not allow an animal to die due to your lack of care. However, in this case, Mrs. Claus provided minimum care, and that's what the statute required. The statute required the state to prove beyond a reasonable doubt that Nancy failed to provide minimum care. The statute also requires the state to prove that Nancy's care resulted in serious injury or death to one of her dogs.
Quick question about minimal
Yes.
care. Is minimal care unique to an animal, or is it universal as to this collection of Shelties? What I mean is there a different standard of minimal care to Shelby because she had a pre-existing condition of a heart murmur?
Your Honor, Mrs. Claus provided the same exact accommodations to Shelby for years, and she had not once had an issue with Shelby. It's unfortunate that Shelby's...
But my question was, didn't she owe her a greater degree of care knowing that she had this pre-existing condition?
Well, Mrs. Claus provided insulated dens, heated food, heated water to Shelby for years. She never once had a single issue with Shelby not being able to be comfortable in those accommodations. It's unfortunate that Shelby's heart murmur finally caught up to her, but it wasn't Nancy's care that resulted in Shelby's untimely passing. It was her heart murmur. Despite Nancy's care, despite her giving Shelby...
And coincidental with a storm and frigid temperatures.
Correct. The temperatures outside the dens in the record reflects that the temperature was 5 degrees. But as we've stated before, that temperature only reflected outside the dens. The only temperature that mattered in this case was the temperature inside the dens.
Well, sorry.
Does minimum care require Ms. Claus to provide any shelter at all?
Well, we would argue that the statute describes minimum care specifically in the statute. It requires food and water, and Nancy provided both of those things. But I would say that with the statute saying such as, it's not an exhaustive list. And Nancy did provide shelter. And I believe it's common sense that, of course, you wouldn't allow dogs to be outside without any shelter. And Nancy never allowed that to happen.
So minimum care does require a defendant to provide adequate shelter.
I would believe that taking the facts into consideration, that weighs in Nancy's favor. She did something that the statute...
Well, answer my question.
Yes.
Does this statute require a defendant to provide adequate shelter?
Yes, Your Honor. I believe it does, especially when it says such as. And Nancy and Mrs. Claus did exactly that.
But your client had a warning, is that correct? The day prior to Shelby's death, your client had a warning from Sergeant Stone that these animals needed above and beyond what she was already providing.
Your Honor, it's true that Sergeant Stone did did come to Nancy's house on January 4th. And he saw those dogs, and he saw those same Shelties in their exact same accommodations and their exact same shelters with the exact same bowls of food and water.
The conditions changed in that time period, is that correct? The snow continued to fall. We heard testimony about the snow increasing to up to 1.5 feet within that time period.
Your Honor, whether the snow increased to 1.5 feet or a couple inches, the fact remains that the dens remained outside. They remained with the insulated hay, providing shelter for the dogs, and the dogs had food at all times. Whether the snow got higher, it doesn't matter because Nancy provided heated food, heated water, and insulated dens for every single one of her dogs.
What inference should we draw from the fact that the barrels were removed the next day?
Your Honor, it was the testimony of Sergeant Stone that he did not have the barrels, or the barrels were not at the location. However, we have no evidence in the record or no testimony suggesting that Nancy removed those barrels.
Well, we know they were removed.
Is she the victim of theft?
Your Honor, it's not the defense's position to prove up their case. It's the state's job to prove their case beyond a reasonable doubt. They gave a reason that the barrels were gone, and in our opinion, it's not reasonable to believe that a 5'2", 120-pound woman removed 46 barrels in a single day. It was the state's job to collect all the evidence, and if Nancy is guilty of removing evidence, then it's the state's job to prosecute her on that. But the state has brought no charges suggesting that Nancy was tampering with a police investigation. It was the state's job to bring forth every piece of evidence. The state failed to prove that Nancy failed to provide minimum care, and they failed to prove that her care resulted in serious injury or death to Shelby.
Couldn't we also infer from the missing barrels that that shows some guilty knowledge on her part?
No, Your Honor, because it hasn't been proven that Nancy was the one who removed those barrels. It was the state's job to present every piece of evidence. If they had evidence of Nancy removing these barrels, then why didn't they press charges against her for tampering with a police investigation? The state has failed to prove.
Why should we doubt Officer Stone's testimony that this is an experienced officer who's been on hundreds of animal neglect cases and investigated hundreds of animal neglect scenes, and he says this is one of the worst situations he's seen. Why should we doubt Officer Stone's testimony that if he didn't remove these dogs, they were going to freeze to death?
Your Honor, it's true. Sergeant Stone has been on the force for 30 years. He's responded to hundreds of animal cruelty calls. But out of those hundreds of calls, he had not once cited a single person for failing to provide adequate shelter.
Doesn't that tell us something, though, about the extremity of these conditions for these animals?
No, Your Honor, and that's because Sergeant Stone went to Nancy's house on January 4th. He saw those same dogs in their same dens with their same bowls of food and water. And he did not issue a citation. All he did was tell Nancy to keep an eye on those dogs. What changed between the 4th and the 5th? It wasn't that the temperature decreased. It wasn't that Nancy took away those barrels. What changed was social media. Sergeant Stone, he went to Nancy's house, Sergeant Stone, when he went back to the police station, apparently some unknown person posted something on Facebook, but we never heard from that person, and we never saw that Facebook post. Then an unknown person tweeted something, a photo, but we never saw that picture, and we never heard from the person who tweeted it. Then there was somebody called the police department, but we never heard from that person, and we have no idea what they told the police. What we do know is that according to Sergeant Stone, this Facebook post, this tweet, this phone call, in his words, put a lot of pressure on him. A lot of pressure to do something. And that something was not based on what the law required. That something was based on what public opinion wanted the law to require. The state has also charged Nancy with animal neglect in the 2nd degree. And unlike Twitter, the state cannot just say Nancy is guilty of this crime and it makes it so. They must prove 2 things, and each of those 2 things beyond a reasonable doubt. First, they must prove that Nancy failed to provide minimum care. And second, they must prove that Nancy's care resulted in pain or suffering to one of her dogs, Cleo. And we've already been over minimum care. Nancy provided heated food, heated water, and insulated dens for every single one of her dogs. This is not the behavior that we would come to expect from a person neglecting her animals in any degree. And that's because this was not neglect. the state failed to prove that Nancy failed to provide minimum care. The state must also prove that Nancy's care resulted in pain or suffering to one of her animals, Cleo. The state has failed to prove pain and suffering because the only testimony that we have, the only evidence that we have is
Assuming that Dr. Vogel was accurate in her opinion that Cleo suffered frostbite, isn't it a reasonable inference that the shelter was not adequate?
No, Your Honor, because it was the testimony of Vogel, who was pressured not to mess up her first necropsy, who was...
My question was, assuming that her testimony is truthful and accurate, that the dog did suffer frostbite, wouldn't the reasonable inference be that the shelter was not adequate?
It's our position that that would not be a reasonable inference. But if the state proved beyond a reasonable doubt that Shelby suffered from frostbite, then yes, then the shelter would be inadequate. But that is not what happened here. The record does not reflect proof beyond a reasonable doubt that Cleo
So you would
suffered.
concede that your client is guilty of animal neglect in the second degree if the state has proven that the dog suffered from frostbite?
Yes, if the state has proven that the dog suffered from frostbite, then certainly frostbite is pain, frostbite is suffering. However, in this case, that is not what happened. The record does not reflect a single documentation regarding Vogel's examination of Cleo on January 5th. All they have is the unsupported testimony of an inexperienced vet who was pressured not to mess up, who had dogs come to her office out of nowhere, brought there by the police, with the police telling her these dogs were housed outside. These dogs were out in the cold. This dog was acting lethargically. That was what was brought to Dr. Vogel.
I'm still stuck on this this fact that you said that Cleo did not suffer. What about emotional suffering? I mean, there's testimony on both sides that Cleo was shivering, shaking, clearly at least afraid of these conditions and what was going on. Why not emotional suffering?
Your Honor, it's true that Cleo was whimpering the January 5th. But what we have to remember is the only person that Cleo had ever known in his life was Nancy. The only place Cleo had ever been in his life was Nancy's house. Isn't it possible that Cleo was whimpering because he was afraid of this new bizarre place that he had never been before?
Was it Nancy's house or Nancy's barrels that he was familiar with?
I believe it's Nancy's house where the barrels are. The only person who had ever cared for him in his life was Nancy. Isn't it possible that he was whimpering because he missed Nancy? The state has not proven beyond a reasonable doubt the cause of Cleo's whimpering. Therefore, they have not proven
Well,
that...
isn't it also accurate that she didn't see these dogs but every 24 hours? So you're suggesting that this bond of seeing them every 24 hours would result in him whimpering for her?
No, Your Honor. There is testimony in the record that suggests that Nancy did not check on the dogs for 24 hours. But Nancy didn't check on those dogs that night because Nancy knew that those dogs had their dens. They had their insulated dens. They had their bowls of heated food and water. She was inside and she could see the dogs from her windows. The state has not proven beyond a reasonable doubt that Nancy failed to provide, that Nancy is guilty of animal neglect.
You know, you said we don't know anything about the temperature inside the barrels because Officer Stone failed to take it, but he did testify that the water that was in those bowls that was inside the barrels was just about to freeze, that it was basically almost ice, that it was icy cold. And this, despite the fact that these bowls were being heated by a heat source. So we do know that it was pretty darn cold in there, don't we?
Well, Your Honor, Sergeant Stone was outside. We don't know if he didn't have gloves on, but if he's outside and he puts his hand in a bowl of water, he's going to think that that bowl of water is freezing. But to determine the temperature, we have a thermometer, and Sergeant Stone had a thermometer, and he never put it in that bowl. The state has also charged Nancy with the assault of a law enforcement officer. But they must prove that Nancy knowingly placed Sergeant Stone in the reasonable apprehension of immediate bodily harm. It's not reasonable for a 6'2", 220-pound armed law enforcement officer to fear this 5'2", 120-pound woman.
Does the
That's
statute say that he
ridiculous.
needs to fear her? I don't see the word fear in there.
Reasonable apprehension of immediate bodily harm. Apprehension of immediate bodily harm, I believe it's just a fancy way of saying that Sergeant Stone thought that he was about to get hurt. They have not shown that that fear was reasonable. For that reason, Nancy's not guilty of the assault of a law enforcement officer. The law clearly defines minimum care. Not Facebook, not Twitter, not public opinion. Nancy provided heated food, heated water, and insulated dens for every dog. And for that reason, we ask you to find her not guilty. Thank you.
Thank you, counsel.
Thanks.
May it please the court. Chase, jump, bark, reasonable doubt. Today, the prosecution has chased their own tail. They've asked you to jump through a series of hoops, and they've barked up the wrong tree in accusing my client, Nancy
Do you agree
Claus.
that one of these dogs suffered from frostbite? Do you concede that?
No, Your Honor. The dog that is alleged to have suffered from frostbite, Cleo, he did not suffer from frostbite.
Well, don't we have a testimony from an expert veterinarian, Dr. Vogel. She went to one of the best veterinary schools in the country. Has been in practice for at least a couple of years. Are you wanting us to believe that she lacks the basic skill necessary to diagnose simple frostbite in a dog?
Yes, Your Honor. This is precisely because Dr. Vogel is a veterinarian with limited experience, and she did not conduct a
How much experience do you need to diagnose frostbite?
Your Honor, a more appropriate level of experience is that offered by Dr. Gruff. He is a veterinarian in this community with
Dr. Gruff is a large vet, right? He doesn't really do dogs and cats like Dr. Vogel.
Dr. Gruff spends primarily his practice focusing on large animals, but potentially up to 49% of his practice can include dogs and cats. So he does have a great deal of experience with dogs. Jump. They've asked you to jump through a series of hoops. In accepting the testimony of a veterinarian with limited experience and that of a bitter ex-lover with a chip on his shoulder, to come to the incorrect conclusion that Shelby passed due to the cold and not the heart murmur condition which she has suffered with her entire life. Bark. They barked up the wrong tree in accusing Nancy of any criminal wrongdoing. This is not a case about the absence of a woman's love for her dogs. This is a case with an overzealous prosecution.
Talk to us a little bit about the animal neglect statute. I want to know whether minimum care imposes any duty on the defendant to provide shelter. And if so, whether the shelter provided in this case was sufficient. What's the defense's position on that?
Your Honor, the defense's position is that Nancy Claus has met each and every part of both the first and second degree as it relates to Shelby and Cleo. All that the law states is that a person commits animal neglect if they fail to provide unjustifiably minimum care, such as food and water, to an animal in that person's custody or control, resulting in death, injury, or pain and suffering. All that this law specifically mentions is food and water. It does not
But that
mention-
doesn't mean that's an inclusive list, right? I mean, your client got a warning the day before all this happened that she was not in compliance with the law, that she needed to do more. Is that correct?
Your Honor, it is correct that Sergeant Stone did come and speak with her on January 4th. However, he did not bring criminal charges until the following day, when the weather was essentially the same as it was on the 4th. Miss Claus is someone who cares for animals. This is because Miss Claus is someone who grew up on a farm. Miss Claus is someone who watched her father raise and care for cattle his entire life.
But does this statute require her to provide shelter to animals in her care?
Your Honor, this should be interpreted by the court depending upon the animal. These are Shelties. These are dogs with thick coats, and it does not specify whether this should include shelter for dogs kept outside. But in this case, Miss Claus provided dens to each and every one
So
of
when
her
a dog
dogs.
dies, minimum care has been provided?
The dog did not die, Your Honor, due to the cold, especially in relation to shelter. Nancy Claus provided each and every one of her dogs with shelter, the dens that you saw earlier in trial. Furthermore, in each and every one of those dens, she included bedding, which includes hay and blankets.
Didn't she provide different shelter to her pets?
Your Honor, it is true that she does have her own pets that she keeps inside and is not a part of her breeding practice.
Did Shelby require a different minimum standard because she had a heart murmur, or the same minimum standard as the rest of the 40-plus dogs?
Your Honor, the law is silent as to whether or not a heart murmur condition or other medical condition would change the minimum standard of care.
Doesn't common sense tell you that at least Shelby should have been provided with a fleece-lined jacket or a blanket?
Common sense does not speak to whether or not a heart murmur condition would be affected by any of the conditions that are present today. So no, it's not necessary that she should have done that. Miss Claus is someone who grew up caring for animals, and it's a part of her DNA. It's for this reason why Miss Claus makes animals such an important part of her life today. Miss Claus is someone who is a dog lover, but more than that, she is an animal lover. And the animals which have stolen her heart are her beloved Shelties. Her beloved Shelties that you can see here. Miss Claus is someone who began to find it difficult, however, to make ends meet after her husband passed away. But there was one bright spot in her life, her beloved Shelties. Miss Claus realized that she could share the same mutually beneficial love and joy that she and her dog shared with other people. That's how she came to become a breeder, which she does today.
Would it also be accurate to describe these dogs as her inventory? As inventory, Your Honor, no. While they are a part of her business, there is no question she is a breeder. They are individuals deserving of the minimum standard of care. They are not merely inventory. And that's because Miss Claus provided all the care that they required under the law. But Miss Claus has been charged by the state today with 3 charges. She shouldn't have been, because Miss Claus is an ABC certified breeder. Miss Claus is someone who takes her job seriously. And Miss Claus is someone who gets to witness both birth and life every day in her job.
It's true that you can be a certified breeder, at least under this particular organization, and keep your animals in squalid conditions, right? They don't actually investigate the breeders that they certify to make sure that the animals are being housed and cared for adequately. Is that right?
Your Honor, there is no evidence of any squalid conditions in the record today. That's not before us. However, to answer your question, ABC certification does not relate necessarily to the treatment of animals. However, we have seen in the record from the ABC certifier that Shelties do indeed have thick coats, and that is why Miss Claus has been fully compliant with the law.
Let me ask you this. If we disagree with you, if we find that the state has proven beyond a reasonable doubt that Cleo suffered from frostbite because she was kept out in the cold, do you lose?
Your Honor, it is imperative that you must find reasonable doubt.
Well, my question is, though, let's say we disagree. We find that that animal suffered frostbite. Do you still lose, or do you lose, or is there something that the statute does that that your client can still be acquitted?
Your Honor, we do not lose, because there is another part of the first 2 charges. Nothing in this section shall be construed to prohibit normal animal husbandry practices. Miss Claus is someone who is engaged in normal animal husbandry practices. And furthermore, the question that you asked does not speak to assault of a law enforcement officer.
Can we stick to the husbandry for a second? I'm sorry to keep harping on this, but when an animal dies, is that in compliance with normal animal husbandry? Does normal husbandry allow for animals to suffer and die in these ways?
Your Honor, there's no evidence in the record that demonstrates that any animals suffered in Nancy's care. But animal husbandry practices blends the time-honored tradition of best practices and the art and science of caring for animals and raising and breeding animals. Nancy is a breeder. And more specifically, she is breeding animals intended to be pets. These are 2 parts of animal husbandry. And the prosecution has brought you no evidence today to demonstrate at all that Nancy did not comply with normal animal husbandry practices. What this leaves you with, in the absence of witnesses that discuss animal husbandry practices, in the absence of any evidence counter to animal husbandry practices, is reasonable doubt.
Well, we do have some evidence about normal animal husbandry practices in this case, don't we?
Your Honor, none of the state's witnesses discussed animal husbandry practices. They may have discussed their opinions related to the care of animals, but they did not discuss specifically animal husbandry practices.
Do you think it's an acceptable practice to visit dogs every 24 hours during blizzards?
Your Honor, yes. Ms. Claus complied with the law, and she complied with normal animal husbandry practices. You should find reasonable doubt in this case, because while Ms. Claus followed her responsibility, as she is certified, as she is experienced, as she follows the law and follows normal animal husbandry practices, there is another party in this room today which has a responsibility, and that is the prosecution. They bear the burden and the responsibility of proving to you beyond a reasonable doubt all of the charges that they've brought today. What that means is that they must prove on each and every element that Nancy Claus is guilty. But Nancy Claus...
What's the mental state for animal neglect in the first degree?
Your Honor...
Do we have to find that your client acted with a culpable mental state, or is this a strict liability crime?
Your Honor, all it says is unjustifiably. So someone must be unjustified in failing to provide minimum care. And there's no evidence that, number one, Ms. Claus failed to meet this, but secondly, that she would have been unjustified in doing so.
Which is it? Either your client provided minimum care or she had an excuse for doing it. What's your argument?
Ms. Claus has met each and every element present before you. Ms. Claus, we ask, did Nancy commit animal neglect by unjustifiably failing to provide minimum care such as food and water to an animal?
I see the language in the statute. So is your argument she met this? You're conceding that shelter is required implicitly in the statute, and your argument is purely that she supplied shelter and therefore you win. Or are you saying she didn't provide shelter but she had a good excuse?
Your Honor, we are not conceding that shelter is a part of this law. However, Ms. Claus met both the food and water requirements, which are the only specifically mentioned levels of care that are required. And more than that, she not only offered food, you heard no evidence to the contrary, she offered water with no evidence to the contrary, and she provided water which was heated. And in addition to that, she did provide the dens, which had bedding inside of them, both hay and blankets. So in each and every way, she has met the law. But she still is in compliance because she participates in normal animal husbandry practices. So, as to the first degree, we ask, simply put, did Nancy fail to do this, and did she fail to have normal animal husbandry practices? The answer is no. Shelby did not pass due to the cold, but rather from the heart murmur condition, which she has suffered with her entire life.
Counsel, just in the interest of not running out of time, could you address count 3 for us, please?
Yes, Your Honor. Count 3 says assault of a law enforcement officer. We ask, did Nancy assault a law enforcement officer if that person knowingly places the officer in reasonable apprehension of immediate bodily harm? Let's discuss all the reasons you should have reasonable doubt as to the third charge. Simply put, did Nancy cause Sergeant Stone to believe that he was going to be injured? But more than that, she didn't. More than that, the prosecution had each and every opportunity to prove this, and they chose not to. Nancy Claus was on that stand today. They could have asked her if she knowingly caused Sergeant Stone to feel apprehension. They didn't. That's because they knew the answer they were going to receive.
Your client was ripping evidence out of the hands of this Sergeant Stone. Why would that not be a factor in this charge? Wouldn't he be in apprehension of losing that evidence?
Your Honor, whether or not he's in apprehension of losing evidence, that is not what is required by this law. That is not one of the elements of this law. What she did was try to protect her beloved dogs and keep her dogs with her.
Well, wait a minute. You just said that the state had every opportunity to ask Ms. Claus whether she knowingly placed the officer in reasonable apprehension of immediate bodily harm. You put your client on the stand, counsel. You didn't ask her that either.
Your Honor, Ms. Claus did state that she said that she believed he did not get injured in any way and that he did not experience any apprehension. So she did indeed say that she believed he had no injuries as a result of their interaction. So the state has failed to prove knowingly. But also, the state's argument falls apart with apprehension. They must have shown that Sergeant Stone literally believed that he was going to be injured. But more than that, he must have been reasonable in doing so. This simply isn't the case. She is a 5'2", 120-pound woman. Sergeant Stone is an officer of the law. He carries mace, a gun, a badge. He has over 30 years of experience. He's an honest man. They had every opportunity to ask him if he apprehended injury from her, and they didn't. It's because they knew the answer that they would get. Of course not.
Well, if he's an honest man, why should we doubt his testimony that these dogs were going to freeze to death if he didn't get them out of there?
Your Honor, this is because Sergeant Stone has been chasing his own tail as his allegations begin at the end. This is because he chose and made up his mind before he ever stepped foot on her property to accuse Ms. Claus of animal neglect. This is because he talked a lot about the cold that was present on the 4th, which was also present on the 5th, but he also talked about the heat that he began to feel on social media. This is because Sergeant Stone made his conclusions based upon the number of likes and shares that a Facebook post of Ms. Claus's dogs received, and which were taken out of context. Sergeant Stone is an officer of the law. He should base his investigation on hard evidence, on facts, on witnesses that
Counsel,
he can talk
wouldn't you agree that Facebook and social media can be a very valuable tool to get information to law enforcement for them to act upon?
Your Honor, certainly Facebook and other forms of social media can legitimately be used by police officers, but it was not legitimately used in this case.
But it appears that the information shared by Facebook was accurate. These dogs were out in blizzard-like conditions, sufficient enough that it caused members of the public to voice their concerns.
Your Honor, the members of the public were people from across the country who did not understand the weather conditions that were present on January 4th and 5th and took the images out of context. And it is based on these calls that he made his decision.
Wait a minute, so you're saying he shouldn't have given your client a warning on the 14th? The 4th, sorry. And then the fact that he didn't give a warning, or gave a warning on the first encounter with your client, that's where it stops. He doesn't have a second chance to revisit the facts, even if he concedes mistake, based on the motivations or the evidence brought forth by an outcry from the social community, the social media community.
Your Honor, an officer is free to give warnings. They do this regularly for people who violate speeding laws. However, if the officer truly believed, as he did on the 5th, that the animals were in the great level of danger that he claims that they were, we have to ask, is the officer failing his duty to save these animals on the 4th, if he truly believed that they were in such danger?
Who cares if he's failing his duty? It's your client's duty to provide the minimum care. And if he made a mistake on the 4th, comes back and corrects it on the 5th, where's the harm and how does that impact this analysis?
The harm is that Ms. Claus has been wrongfully accused. The prosecution wishes you to believe that the only victims are the dogs as a result of negligent care in a blizzard. But the only victim in this case is Ms. Claus. She has been subjected to a blizzard of accusations by the prosecution based primarily on the likes and shares that Facebook posts have gotten. That's not how our justice system works. Our justice system is based on hard evidence, facts, and the law. You have the opportunity today to participate in the greatest justice system that this world has ever seen, great in part, although it may not be perfect, because each and every one of us is assumed to be innocent until proven guilty. You have one of the greatest roles in our justice system, to stand between the accused and an overbearing prosecution, ensuring that they must prove each and every one of their charges and elements beyond a reasonable doubt before the accused will face any consequences for which they've been brought. However, the prosecution should not be allowed to get away with chasing by basing their investigation on the number of likes and shares on social media. They should not be allowed to get away with jumping, asking you to jump to illogical conclusions. They should not be allowed to get away with barking up the wrong tree and accusing Miss Claus of something she did not do based upon the testimony of a bitter ex-lover with a history of trespass. We ask you to find a verdict which ends the prosecution's chasing, jumping, and barking, and finds reasonable doubt in the prosecution's case. Today we ask you to find a verdict which the evidence demands and which justice requires. Today we ask you to deliver a verdict of not guilty on all counts.
Right on the
Thank you.
spot.
Thank you, counsel.
May it please the court. Unjustifiable action, unmistakable result, and undeniable guilt. Animals can communicate, and they do. And through the chattering of their teeth, the shaking of their bones, and their whimpering, Shelby and Cleo were communicating. But this communication was ignored when the defendant chose to unjustifiably provide minimum care to these dogs. The result? Unmistakable. Pain, suffering, death.
Does the statute actually require Ms. Claus to provide shelter? I only see food and water
It is,
there.
Your Honor, it is such as food and water. That is a minimum requirement, and that is just an example. So adequate shelter would fall under that, Your Honor.
Well, how so? Why does this, tell us more about why you think this statute requires a person to provide shelter to an animal. We've all heard of outside dogs, outside cats. Livestock are frequently kept outdoors. What is it here that we're supposed to infer that imposes a duty on Ms. Claus to provide shelter?
Your Honor, we're looking at a duty to provide minimum care to a dog. Care would suggest adequate shelter. In this instance, the statute is requiring such as food and water. In this specific instance, the dogs were she unjustifiably failed to provide minimum care, such as a blanket, adequate bedding.
We heard from Dr. Gruff, though, who's really an established vet in this community, that people keep their dogs outside all the time. You know, we're not in the city here. This is out in the country. How do you speak to that?
The day that Sergeant Stone, Your Honor, the day that Sergeant Stone arrived to the defendant's property, he realized that these are Shelties and they have fur coats. But she was not engaged in these normal animal husbandry practices. It was clear that these dogs were in pain and they were suffering.
Wait a minute. How do we know that? How has the prosecution demonstrated beyond a reasonable doubt, A, what the animal husbandry practices are for Shelties, and B, that Ms. Claus didn't live up to them? As far as I can recall, the only evidence we have in the record came from defense witnesses, Dr. Gruff, and the certified, the breed certifier, talking about what the standards were, and they basically said that Shelties are dogs that are bred to withstand super cold temperatures, and it's common for them to be kept outside. So how's the prosecution met its burden? How do we not have an honest uncertainty about whether she did meet up to these standards, live up to these standards?
Your Honor, we heard from Dr. Gruff today, the defense's expert witness. He didn't specialize in small animals. He didn't specialize in dogs. He actually did not perform any tests on these dogs. He didn't see them the day this crime occurred. But we did hear from Dr. Vogel, the state's expert witness, who said that these were small dogs who were not built to endure the type of conditions that they were forced to that day.
Is it fair to be concerned with Dr. Vogel's lack of experience?
Absolutely not, Your Honor. She went to a prestigious school, she had adequate training, and she was with a team of experts that assisted her that day. Count 1 and count 2 are almost identical. The only difference is the victim and the seriousness of the crime. Count 1 asks, did the defendant commit animal neglect in the first degree? You should find that the defendant committed animal neglect in the first degree. If the defendant unjustifiably failed to provide minimum care, such as food and water, to an animal in that person's custody or control, which resulted in death to that animal.
Let's say that we agree with you and that minimum care was not provided in this case. What would be an example of justification for that? What do we make of this unjustifiably language?
In this situation, Sergeant Stone was at the defendant's house the day before the massive snowstorm occurred in this county. He told the defendant that this storm was coming. He told her that these dogs were going to need proper shelter. He told her how to follow the law, and she refused. He arrived the next day after an outcry from social media, seeing that a foot of snow had fallen, and there was snow on these dogs' faces and fur. There were icicles forming on their noses and chins. Sergeant Stone found that she didn't provide adequate shelter.
Didn't Sergeant Stone merely test the temperature outdoors and fail to actually record the temperature inside the barrels?
Your Honor, when he saw these dogs, he realized that this was a crime scene, and that if he didn't get these dogs out as soon as possible, they could die. But to answer your question, he did take the temperature outside, but not inside the barrels, Your Honor. And the next day when he arrived, the defendant already had taken these barrels. There was no way for them to even do an investigation on them. Count 2 asks, did the defendant commit animal neglect in the second degree? And you should find that the defendant committed animal neglect in the second degree if she unjustifiably failed to provide minimum care, such as food and water, which resulted in pain and suffering to that animal. Simply put, did the defendant commit animal neglect in the first degree when she refused to add a simple blanket in the barrels for these dogs, which refusal resulted in the death as to Shelby? And did the defendant commit animal neglect in the second degree when she refused to add a simple blanket in Cleo's barrel?
Well, Ms. Claus did testify that she was in the process of getting some blankets out of the attic at the time that the police arrived on the property.
Your Honor, she did testify she was getting blankets, but she did not clarify what she was planning on doing with these blankets. We don't know if she was making her bed. We don't know if she was putting them outside.
If Shelby died of a heart murmur, should Mrs. Claus be accountable?
Your Honor, if Shelby died of a heart murmur, she should be accountable because she left a sickly dog outside in a massive snowstorm. Although there is no evidence brought forth today that Shelby had a heart murmur.
Wait a minute, no evidence that the dog had a heart murmur?
There's no solid evidence, Your Honor.
Okay, you mean, okay.
Dr. Gruff claims that there's a possibility that Shelby had a heart murmur, but he did not perform any actual tests on Shelby.
He said he heard a swishing sound, though, right, when he listened to her heart?
Yes, Your Honor, but he has adequate tools to perform these tests to find this out definitely, and he performed no such tests.
So if we find that the dog died of a heart murmur, do we still have to convict her of animal neglect in the first degree? Is she still responsible for that dog's death if the death was from a heart murmur and not from hypothermia?
Yes, Your Honor.
Posited by Dr. Vogel?
Yes, Your Honor, absolutely, because she failed to provide minimum care to these dogs, which resulted in the death of Shelby and the pain and suffering of Cleo. We found that Shelby, when Dr. Vogel performed
How do we know that Cleo was actually suffering?
Your Honor, when Sergeant Stone took Cleo to Dr. Vogel's veterinarian clinic that day. She was the only vet clinic that was open. He wrapped him in blankets. He had the heater blasting. And after an hour, his body temperature was still below normal. He suffered from hypothermia. And this is caused when your body loses heat too fast and it can't produce heat quick enough. And it is well known in the scientific community that animals feel pain, just like we do. And so when a dog suffers from hypothermia, they can get frostbite. And when those body parts start to warm up, the effects can become extremely painful. Those body parts can swell, turn black and blue, lose function, or even fall off. And
Who testified to that?
Dr. Vogel told us the effects of hypothermia and that it can be painful, Your Honor.
Yeah, who testified that the body parts could fall off?
There was no testimony today, Your Honor. And Cleo suffered frostbite on his tail, on his two front paws, in his 2 little ears. So it's common sense that when a small dog is left outside in a massive snowstorm, with his body parts slowly deadening, that he felt pain and he was suffering. So did the defendant unjustifiably fail to provide minimum care to these dogs in such a way which resulted in the death as to Shelby and the pain and suffering as to Cleo? Undeniably, yes. So how did the defendant try to get away with it? We heard today that when Sergeant Stone arrived to the defendant's house, suddenly the defendant starts running outside, screaming at Sergeant Stone, attempting to grab the dogs out of his grip. She digs her nails into his arms. Count 3 asks the question, did the defendant assault a law enforcement officer? You should find that the defendant assaulted a law enforcement officer if she knowingly placed the officer in reasonable apprehension of immediate bodily harm.
How could he reasonably be in fear when she is literally half his size?
Your Honor, the defendant sat on the stand and she said that she's about my height, my weight. But Sergeant Stone is an officer of the law, and he can't afford the opportunity to give everybody the benefit of the doubt that is running up to him, physically grabbing him and digging their nails into his arms, that they're not going to hurt him. It is his duty, his civic duty, to protect us, to protect our community. And what type of effect would it have if we let everybody assault our law enforcement officers?
Did Officer Stone testify that he was afraid that Ms. Claus was going to hurt him?
Your Honor, Sergeant Stone testified that he was attacked by the defendant, but he did not use the words afraid, Your Honor. So
under the canons of statutory construction in a criminal context, where you're assessing the officer's apprehension or lack thereof, is that an objective or a subjective test?
Your Honor, I do not have the facts for that before me today. It is more than likely objective, reasonableness.
You need to look it up and get back to us. That's fair.
Yes,
All
Your
right.
Honor.
Can we go back? I'm sorry, I don't think you addressed that last line in both of the neglect statutes talking about animal husbandry. I mean, we heard testimony about the fact that dogs in this community are left outside all the time. Why should the defendant's counts not just be dismissed based on the fact that she was acting in accordance with standard practices in her community?
Your Honor, that's a great question, because animal husbandry allows for people in a small community to allow their dogs to stay outside. And that's okay, that's normal. But when a massive snowstorm is taking over your county, it is not justified to leave these dogs outside without minimum care. They're okay outside if she were to provide them with what they needed. And we have evidence today, the fact that we have a dead dog, another that suffered, that she didn't provide that minimum care. She wasn't abiding by normal husbandry practices. And as to count 3, she acted knowingly. We know that the defendant acted knowingly. If she acted with an awareness that a particular circumstance existed or that her conduct was of a particular nature. We know that she was acting with an awareness that a particular circumstance existed because she came running outside, screaming at the officers to stop, digging her nails into Sergeant Stone's arms in order to get him to stop. We know that she was acting with an awareness that her conduct was of a particular nature when she grabbed an officer of the law. She put her hands on an officer of the law. She showed a lack of respect for the law that day. And what kind of excuses did the defense bring you today? Dr. Gruff. Dr. Gruff didn't specialize in small animals. He didn't see the animals that day. He didn't conduct any tests to bring forth today and show us that Shelby had a heart murmur. He just sat on the stand and fed us excuses when he has no evidence to back it up. We heard from the defendant. We heard that she refers to her breeding dogs as her little cash cows. She said that she doesn't have enough money to provide these dogs with proper shelter. She couldn't put them inside because her house wasn't big enough.
A question. Is it reasonable to infer that charges were filed because of pressure due to Facebook postings rather than the real merits of these dogs freezing?
Absolutely not, Your Honor. It is 2015, and this is how police investigate these days. This is how they get tips from the community that crimes are occurring.
Does it matter whether the prosecution chose to file these charges because of political pressure or not? Is that even something that we should consider?
Absolutely not, Your Honor. The fact is that the crime occurred, and there needs to be justice for this crime. We heard from the defendant that these were her little cash cows. That's all we need to hear from her. But she also said that she didn't have enough shelter.
Is it a crime to breed dogs?
Absolutely not, Your Honor. But it is a crime to, there's one instance where she has her pet dogs, her inside dogs. And in that same day, just to let them go outside to use the restroom, she put fleece jackets on those dogs. But Shelby and Cleo and her other cash cows, they were refused something as simple as a blanket.
How can we be sure that the dogs suffered frostbite and so forth without photographs to substantiate what Dr. Vogel observed?
It's her testimony today, Your Honor, that these dogs suffered from hypothermia. She has been designated as an expert witness today by the court. And without these pictures, we are relying on her testimony, Your Honor. It's been said that the greatness of a nation and its moral progress can be judged on how it treats its animals. Dog is man's best friend. Through dogs, we're shown this unconditional love. Not an unconditional love that we always deserve, but one that is always there.
Does the statute require us to have any different standard of care for dogs or cows or pigs, or isn't this a universal standard? Does it matter whether dog is man's best friend?
Your Honor, the statute refers to animals in general. And animals can communicate, but differently. Can you hear them? Shelby, Cleo, whimpering, bones shaking. Can you hear them? Shelby is dying. Cleo is in pain and suffering. The unmistakable result, the death of Shelby, the pain and suffering of Cleo, and the assault of Sergeant Stone. Your undeniable verdict. Ms. Claus is guilty. It is now your opportunity to put these dogs in perfect speech into action, to give a verdict based on the overwhelming evidence. We ask you to find Ms. Claus guilty of animal neglect in the first degree, find Ms. Claus guilty of animal neglect in the second degree, find Ms. Claus guilty of the assault of a law enforcement officer. Find her guilty.
Thank you.
Thank you, counsel.
Thank you very much.
My name is Alina Nello, and I am arguing for the defense of Ms. Nancy Claus. May it please the court. Your honors paid careful attention to the important evidence presented yesterday, and this means everything to my client, Ms. Claus. Ms. Claus is innocent, and the prosecution has certainly failed to meet its burden. The evidence you saw yesterday suggests that the only reason this case even came to trial was because animal rights activists in other states managed to convince the police department, the sheriff's department, and the prosecution to use this case to promote their radical animal rights agenda.
Does it matter why the case came to trial? How does that bear on the evidence before the court to determine whether they've proven that your client is guilty of animal neglect? Does it matter why they chose to file the charges?
The reason why the charges were filed, well, first of all, even without discussing that, if you'd like, I can just get into explaining why these laws are, the laws that the prosecution mentioned are inapplicable to Ms. Claus. But understanding the reason why this came about can help us to assess the credibility of the testimony given by the prosecution's star witness, Officer Stone. Officer Stone, who you saw yesterday, may be very well-meaning, but his testimony suggested bias and a concern about pleasing animal rights activists.
How is Sergeant Stone biased? I mean, this was the first case that he even cited for shelter in many years of working on animal cases. Is that correct?
Well, Stone has let us know that he personally sees himself as the animal whisperer, that he thinks animal abuse cases are the worst types of cases, and he said that right after mentioning he also sees child abuse cases. And Stone also let us know that he feels there have been hundreds of cases of animal cruelty that he investigated. Whether or not he cited, he feels like he investigated hundreds of cases of animal cruelty right here in Polar County. So in your expertise as a judge, if you feel like it's hard to believe that there have been that many cases of animal cruelty in Polar County, you might want to question whether this officer's understanding of animal cruelty is exactly the same as the statutes about animal cruelty, and whether his understanding is the same as the understanding of people who work with animals and who farm. In addition, the evidence suggests that while Stone might have realized in the past that his concern about animals didn't mean that a crime had been committed, in this case, the evidence Stone presented suggested that the main reason he cited the animals was because of a desire to please animal rights activists who contacted the sheriff's department. And so if he had never been contacted by animal rights activists in previous cases, that could explain why he hadn't actually brought citations in previous cases.
He had given her a warning the day prior, though, right? So he was aware of the situation. He told her that she needed to do more. So she was on notice that this was an issue.
Though you're saying that Stone testified that he gave a warning to Ms. Claus the day before, and it's definitely something that you as a fact finder need to decide. But there's also evidence, which was the testimony of Ms. Claus, saying that she didn't feel Stone had given her a warning. Her understanding was that Stone was just doing the rounds, checking on everyone in the cold weather, and that Stone, by coming by her house and not giving her a warning, was implicitly approving of the way she was treating her animals.
Aren't her actions in giving her personal pet fleece jacket indicative of her understanding that this was a severe blizzard?
So Ms. Claus did mention that she put a jacket on the pet that she keeps inside, and something we see here in Polar County is that people generally have one way that they treat pets and another way that they treat farm animals. So that doesn't necessarily, you could still be treating your farm animals well while you treat them differently than your pets. So somebody might put a jacket on their Chihuahua but not put a jacket on their cow and still be treating their cow appropriately. In addition, people dress up animals for all sorts of reasons, sometimes for cosmetic reasons. It's not clear that Ms. Claus was putting this jacket on her dog because she felt the dog would be in danger otherwise. In addition, Ms. Claus's indoor dog, who went outside, was just running around in the field without any kind of protection, whereas the testimony you saw yesterday showed that the animals who lived outside they were inside kennels. There were 2 dogs to a kennel, so they had body heat. There was warm straw in the kennels, and there was snow on the outside to insulate the kennels even more.
Who testified there were 2 dogs to each barrel?
I believe that was Officer Stone. I can double check.
Well,
get back to us.
Yeah.
Okay.
Regardless of the reason that the charges were brought, that does not change the temperature that was registered in the thermometer on State's Exhibit 101, which is 5 degrees. How is keeping animals outside, dogs outside in 5-degree weather, how can that possibly be said to provide a minimum level of care?
So that's a good question. Officer Stone did record that temperature outside, and something very interesting, very important for you to think about is that Officer Stone used a portable thermometer, which he mentioned he had, to record that temperature. And he mentioned that in the past he had inserted that portable thermometer into hot cars to measure the temperature inside a car. But for some reason in this case, he chose not to present any evidence about the temperature inside of the dog kennels. With somebody with 30 years of experience, you can imagine Stone would likely have considered that if he wanted to know what temperature the dog's living environment was, he could have put the thermometer inside the kennels before taking the dogs out to check the temperature there. Presumably the temperature, you could imagine, would be much warmer than 5 degrees there.
But isn't it also a reasonable inference that it was cold enough in the barrel to cause frostbite?
So the evidence about frostbite is coming from Vogel, this new vet who's only been working for a couple of years. And she's testified that she had trouble finding work. So this was one of her first times really probably having this type of a case, you can imagine. She had 46 animals to look at. And after looking at all 46 animals, she only found one animal that the prosecution has told us about where she felt that there was frostbite. And it's possible that there could be some reason the dog could have been putting their body parts outside of the kennel if we're to believe that this happened. Something I wanted to mention about the frostbite though, and also what you were saying about minimum care, is that the statute, the animal neglect statutes require, in order for somebody to be guilty, that it must be proven beyond a reasonable doubt that they caused the animal's death in the case of first degree or bodily harm, and in the case of second degree that they caused the animal pain or suffering. So even if we were to believe Vogel that this animal had frostbite, the person couldn't be guilty of animal neglect unless they had caused the animal pain or suffering because of this frostbite. And if we listen to Vogel's testimony, Vogel testifies that frostbite only causes pain when the animal begins to warm up. Now, in this case, it's sort of ironic because the police officers...
Whoa. You're not really going there, are you? That's like saying, you're going to say that because the state's vet or the state, through its hired vet, warmed this dog up and it experienced pain, it's the state that caused the pain and suffering of the animal? Are you going there, really?
I'm not arguing that we should charge the state.
The vet that pulls the bullet out is causing the pain in a homicide case where the patient ultimately dies. Is it not?
I mean, I'm not saying we should charge the state with animal cruelty or anything like that, but it seems...
It's the state's fault, right?
It just doesn't seem like it's Ms. Claus's fault, especially because another thing the state is angry with her for is the fact that she tried to keep the dogs where they were. But I wanted to mention something about these animal neglect statutes before we go on. The statutes have multiple important elements that you need to consider, and one element you definitely need to consider is that both statutes have an exception for normal animal husbandry practices. So no matter what you decide about minimum care, no matter what you decide about pain or death, you must acquit Ms. Claus from both animal neglect charges if you find that she was practicing normal animal husbandry practices. And from your experience working in this farming community, you probably come to see that normal animal...
Wait, whose experience? I'm sorry, that is... wow. Whose experience in the farming community?
I'm saying your experience as judges in
Mine?
Boulder County. I mean, even if you haven't personally experienced this...
I've never farmed in my life. I don't know about my co-judges.
I just meant that I think we probably know that farmers often keep their animals outside. And specifically, we have evidence that breeders, specifically Sheltie breeders, can keep their animals outside, and that this is a normal breeding practice.
So where do we draw the line then? A dog is dead, you concede that, correct? So is it normal animal husbandry when a dog dies as the result of those practices?
Well, in this case, the evidence actually, the weight of the evidence suggests that the reason the dog died was because of a a heart murmur that the dog was born with. The prosecution has failed to prove beyond a reasonable doubt that Ms. Claus caused the dog's death, and in
So
fact,
shouldn't your client then take that into account in her treatment of Shelby, that Shelby had this condition? Why not bring at least Shelby inside during this blizzard?
That's a good point, and I do think, perhaps if somebody was doing the most exemplary, absolute best care of an animal ever, maybe, especially if they had all the money and resources available, that could be something that they would consider.
Well, it begs the question, on an animal husbandry exemption, does that animal husbandry exemption apply to the herd or the population as a whole, or to each individual animal? What's your position?
My position would be that that applies to the herd as a whole.
What do you have to offer in support of that?
Well, the vast majority of animal husbandry, maybe not in Polar County, but in the country, is now moving to large-scale, giant, concentrated animal feeding operations that have many, many animals. So to hold these people accountable for what happens to every single animal when they're responsible for caring for millions of animals doesn't really seem practical.
So you're saying puppy mills equal factory farms?
I mean, I don't think that anyone's talking about a puppy mill in this situation. These dogs, that's a term that's usually used for a really different type of situation. This was a responsible ABC certified breeder.
Even worse then, breeders equal factory farms.
I'm just saying that animal husbandry exemption is designed to talk about people who care for large number of animals. And that I don't think the exemption is, well, I guess what I'm saying is that normal animal husbandry is not to make a specialized medical-based plan for every individual animal. That normal animal husbandry would usually treat animals as a group.
So there's an acceptable failure rate in animal husbandry when you're dealing with a large population of animals, and a certain number of animals might suffer and die as a result of that intensive use of the animal in that context.
To your theoretical question, I would say yes. In this case, though, I don't believe, the evidence does not show that Ms. Claus's keeping the dog outside caused the dog's death. If anything, if you think about an animal with a heart murmur, and that animal dies suddenly, the kind of thing that's likely to provoke somebody with a heart condition to die is something that would cause fear or stress. So we know that this animal was alive on January 1st, 2nd, 3rd, 4th, when it was very cold. The animal was alive. On the morning of January 5th, it wasn't until the animal control officer and the police officer took this animal out of the kennel where the animal had always lived and away from the woman who had always cared for the animal, and threw the animal into a cage in a car, that this animal died. So the great weight of the evidence suggests that the animal died of a heart murmur, and if anything, you can infer that the heart murmur was likely to have been provoked, that the heart murmur was likely to have been set off by this scary change, rather than by a cold weather which had been going on for years and which the dog seemed to be thriving in.
Is it justifiable to only check on animals every 24 hours when one has a pre-existing serious medical condition and the group is facing blizzard conditions?
That's a good question, and again, I think that there could be a way that we could describe the most ideal, luxurious care for an animal that would involve constant monitoring, but I think that right now, what we're looking at is serious criminal charges. We're talking about taking away somebody's freedom and putting them in prison. And before we do that, we need to make sure that they actually fell below a minimum standard of care, which is what the law requires, and that they fell below that standard of care beyond a reasonable doubt. So the law doesn't ask whether there's something better Ms. Claus could have done. It just asks whether what she did met the minimum. And I think you can probably see in your judgment that checking on dogs once a day, making sure that they have food, water, shelter, bedding, veterinary care, that meets at least the minimum standard of care and is certainly in line with normal animal husbandry.
Does the defense concede that Cleo suffered from frostbite?
It would have been really, no, the defense does not concede that.
Let me rephrase my question. Does the defense concede that the state has proven beyond a reasonable doubt that Cleo suffered from frostbite?
The defense does not concede that.
Okay, so my follow-up question is, if you do not concede that, why should we have an honest uncertainty based on that on the testimony of an Ivy League veterinarian who went to one of the top 10 veterinary schools in the country, who has at least a few years of experience, who examined this dog and diagnosed it with frostbite. Why should we have an honest uncertainty about that?
So there's a few reasons. One reason is that Vogel, even though she had a education from a great school, she admitted that she had only been practicing veterinary medicine for about 2 years at the time that she saw these dogs. And she also admitted that she had a lot of trouble finding work during those 2 years. So we can infer that she had very limited experience. We also know that on this day she had to see 46 dogs. So after seeing 46 dogs, looking at all of their skin, trying to do her best, it's hard, it doesn't really provoke confidence that you can be 100% sure that Ms. Vogel was definitely coming up with the right diagnosis. And especially when we consider that there's no photograph for us to look at. It would have been great if maybe Vogel had thought of that, or at least if Stone, who has much more experience as an officer than she has as a vet, had asked her for a picture. That would have been something that would have really helped in this case to decide one way or the other.
Didn't she testify, though, that Cleo's skin had turned a different color? I mean, isn't that testimony, why shouldn't we take that into consideration just with equal weight that we would a photograph?
So Ms. Vogel did testify that, and after I get to your question, I just want to make sure I mention the last assault charge before this ends. But yes, Ms. Vogel did mention that she felt the animal's skin had turned a different color, which is something that I really wish we could see a photograph of. So it's possible that she is telling the truth. I'm not saying it's impossible that this would be true, but it's not proven beyond a reasonable doubt. First of all, because we know that Vogel has a bias and has her own interest in the outcome of this case, because Ms. Vogel testified that she's written a paper in which she advocates for the radical animal rights position that the death of an animal should be treated the same as the death of a person. So when we're listening to a witness like this who has a bias and has limited experience, and isn't providing us any physical evidence, it's hard to be certain of what she's saying beyond a reasonable doubt. In addition, while you wouldn't expect a dog's skin to be bright blue, dog's skin does vary from different dogs or even on the same dog. And so it's hard to know if what she perceived as blue was really just slightly darker than other skin or something along those lines.
Counsel, would you please move on to the assault
Yeah,
charge?
thank you so much for bringing that up. So the last clause that the prosecution sort of tacked on at the end was assault of a police officer. And the definition of that is it only applies when a person knowingly puts an officer in reasonable apprehension of immediate bodily harm. So, I'm forgetting to use my slides. Well, let's just go on to the word reasonable. It's not supposed to look like that.
Reasonable.
Yeah, it didn't look like that on my computer, I promise. So, you saw Ms. Claus on the stand yesterday. You saw she's only 5 feet 2 inches, weighs 120 pounds. You saw she's a widow, and then you saw Sergeant Stone. You saw he's 6 feet 1 inch, weighs 220 pounds. That's almost twice Ms. Claus' weight. He's presumably carrying a gun because he's a police officer. He has 30 years of experience as a police officer. So the first question we need to ask is there any way it would be reasonable for this large, strong, experienced police officer with a gun to fear immediate bodily harm from a little widow coming to try to save her dog?
Does the statute require him to experience fear?
Well, reasonable apprehension of him. Okay, so the question is whether it would be reasonable for him to expect that he was about to experience bodily harm from this little woman. And I think that in your wisdom, you can see that it would not be reasonable for a man like that to expect that he's going to receive bodily harm from a woman like this. Then the next question is whether he actually did expect bodily harm.
I'm going to go ahead and cut you off right
Okay.
there. You ran out of time, but
Thank you, counsel.
for your time.
appreciate it.